Okay, Scott Siegel is here with us today. He is a founding member of Siegel and Amos in Charleston, West Virginia. Mr. Siegel is a nationally recognized trial lawyer known for representing victims of catastrophic injury, wrongful death, and complex mass tort and class action litigation, which is all a little bit familiar to us as tort students. He is a 1981 graduate of the West Virginia University College of Law and the recipient of the Justitia Officium Award. And he has secured landmark results, including a $405 million jury verdict in a gas royalty case. And he has led major litigation involving asbestos, pharmaceuticals, and defective products. Mr. Siegel is a member of the Inner Circle of Advocates, and in fact is the only West Virginia lawyer in history to have been invited to the Inner Circle of Advocates. And that organization is limited to the top 100 plaintiffs' lawyers in the United States. He has been recognized by Best Lawyers in America and Martindale-Hubbell for more than 2 decades, and he frequently teaches continuing legal education programs nationwide. So we are honored to welcome him to share with us his extensive knowledge and his insights on advocacy in all torts, but particularly in complex litigation. And so please join me in welcoming him.
Good afternoon. Good afternoon. Very good. So, real case, and it was actually tried to a jury in Kanawha County. The second case, if we have time for it, was tried to a real jury in Princeton, Mercer County. And what I'm going to try to do today, in the short time we're going to get to spend together, is give you a feel for how do we in the courtroom explain to a jury what you all are learning, okay? So for instance, you've all heard about the reasonable person test or the reasonable corporation test. That instruction gets read to a jury and their eyes glaze over. They don't know what the judge just said. They don't understand and haven't been with 2 fine professors like you have to understand what that means. And they're like, what the heck is all this about? And then they get to the instruction about proximate cause. Forget it. They are clueless in Seattle. And it's your job in a couple of years to help the jury understand, and sometimes the judge, what the heck fits from this part of the case with that part of the case. So I began this case realizing it was a complex case involving a lot of chemicals. For those of you who hunt or do outdoor sports in the winter, you know what these are. And so what we're going to do right now is we're going to create a basic, very simple chemical chain reaction by exposing this chemical to air. We now have begun a chain reaction. Somebody make it stop. Come on, you got to make it stop. Someone make it stop. No. Okay, throw it away. Now, actually, the jury wasn't allowed to do that. They had to sit there and look at it and wonder why I was yelling at them, because at the end I was yelling, just like I was with you, to make it stop. And I said to them, that's all the chemistry you need to know. I'm going to bring you some of the finest chemists in the world to explain that to you and to what happened. But you now understand everything that happened that day. So who are we talking about? Clarion. We got to talk about a company, and we got to introduce the jury to who the company is, because you're going to tell them in a minute that that's how you're going to prove that the reasonable company standard was violated. Now, you got the judge giving the instruction, but how about if the corporation itself has used its own words to talk about what a priority safety is, how wonderful they are at safety in the environment, and their integrity for doing all this the right way. You're now using their own words in opening statement, their own safety standards as the reasonable person, the reasonable corporation. They've defined it for you. And then you tell them, what were they supposed to do? They were supposed to ensure the accuracy and sufficiency of information. And then you go through these things generally, explaining to the jury what they didn't do. After you've told them what they did do, then you say what they didn't do. And you go on to talk about the knowledge that they failed to give to the people who were going to run this reaction, the things they failed to provide that were critical to doing this safely. All of the things with regards to a chemical called CBD 56 and how it would decompose and at what temperature it would decompose. Technical data, all the things they failed to tell the company that was going to try and dry this chemical. And how much of this chemical were they going to try and dry? 8,000 pounds. A process hazard analysis. Now, this is really good stuff for a jury to understand, because a process hazard analysis is nothing more than what any one of you reasonable people would do if you were trying to figure out, how do I safely dry a chemical that's a crystal? How am I going to do that? How am I safely going to dry that so that it doesn't become a runaway chain reaction? And these are all the things that you do during a process hazard analysis that every single chemical engineer in the Valley understands you have to do this. And did they run any tests to see what would cause a chain reaction and at what temperature? No. The first batch was 8,800 pounds, and a super sack, which was in the courtroom, is bigger than both these tables. That was their preliminary test. Now, the other thing you want to do if you're talking about a reasonable company is, what's the reasonable alternative? It's easy to blame someone, right? They didn't do this, they didn't do that. No, show them that there is a safe way to do it. In fact, this is the machine Clearon used to use. And it was sitting in South Charleston, West Virginia, taken apart. And instead of using it, it's called a fluid bed dryer, they decided they wanted to hurry up and not spend the money to recommission the safe way to do it. They had done it for years safely. And you know what the most important part about that little gizmo is up there? And it's not so little, it's bigger than this room. If you get a runaway chain reaction, the entire system floods. Floods. That's how you stop a chain reaction, is you flood it, or in the words of the chemical engineers, you deluge it. Instead, these rocket scientists decided they were going to hire a company in an old chemical plant in Charleston that used to be DuPont. It isn't anymore. And they were going to use this thing called a double cone dryer. No one had ever tried to do this in a double cone dryer. No one. And on the witness stand, our chemist told the jury that if you try and dry this chemical, these crystals, in a double cone dryer, you will have an explosion. Not you could, you will, every single time, because that cannot be used to dry a chemical that when it reaches a certain temperature, it's going to run away and explode. So what happens when you cut corners, ladies and gentlemen? That's a doorbell cam clear on the other side of the Kanawha River. Now, I had all this beautiful video from the news media because it was on everybody's morning news the next morning. I had all these great photographs, and you say, why in the world did you use a doorbell cam? Because in West Virginia, doorbell cams ain't fake news. And if you go to YouTube, you'll see deer on doorbell cams, black bear, people stealing packages. That's why I didn't use those nice pictures. I showed them to the jury, but I used the doorbell cam to make the point. This is what was left of the buildings where this explosion took place. Now, you talk about cause and fact, proximate cause. What does cutting corners do? You show the jury where poor John was found. And John lived for 3 hours, 1 hour and 16 minutes of which I could prove he was conscious. And so now the jury knows exactly where his body was found, and I won't take all the time today to do it, but he was standing directly in front of that double cone dryer when it exploded because his boss told him, you need to go down there and spray water on it to see if you can cool it off. Unfortunately, the water didn't deluge the inside of the dryer, and John was standing there when it reached its critical temperature. Now, proximate cause. How does it injure the person? How does it wind up? This is what your lungs do when they're healthy. They take oxygen in, pull it out of the air, take the bad air, the CO2 out, and you exhale the CO2. Now, if you breathe a chemical, such as chlorine gas, like they outlawed after the First World War, which is exactly what this was, what happens is you begin to drown on your own fluid. The judge granted a motion that I could not use the word drowned, and my experts could not. We had to use the scientific term, which is air hunger. The good news is, when my client John was put into the ambulance, he said to the ambulance driver, I'm drowning, help me. And the ambulance driver recorded that in the run sheet and testified to it twice in his deposition when John said to him, I'm drowning, help me. And the judge said, that's his dying declaration, it's admissible. And so it came in, and I was able to explain to the jury how the fluid begins to build up in your lungs, and the sensation that you feel is one of air hunger, which people who drown, and I couldn't use that word, will actually leave their fingernails in things they're trying to open or pull off so as not to drown. Now, once again, I showed you how this could have been avoided. Well, how about a little bit more? How about a simple little test? A test that cost, whatever that, $240? After they took John's life, they sent that much chlorinated dry bleach to a lab. And for $240, they were told that at a temperature much lower than anyone believed. Not only would it explode, but this was a runaway exotherm releasing heat. Runaway exotherm. The cell exploded before the exotherm was ended and the reaction couldn't be completely done. And there's the blown up cell. In closing, I said that they blew up the machine and the defense lawyer got real upset about that. What do you think the jury thought? You think they give a difference between the cell and the machine? That's how much of this chemical and $240 could have saved John's life. This was a very, very important slide. Remember I told you in the beginning I'd bring the best chemist in the world to explain to you? So he's 80 years old. He's produced hundreds of tons of this stuff in Tennessee over his career. I put him on the stand and said, you ever been before a jury before? He goes, thank the Lord, no. This is his own calculation of how much 8,800 pounds of this stuff equals to dynamite, TNT. Give the jurors something they understand. 8,800 pounds of DB56 or chlorinated dry beach don't mean nothing to a jury. 1.9 tons of TNT. Now you're going to get some nodding heads in that jury box because that makes sense to them. But I wanted them to see all the steps he had to go through to explain how an exotherm runaway chemical reaction happens. And so he explained all this. The other thing I never want you to lose sight of when you're talking about proximate cause and cause and fact, these are real people. This is not Mrs. Palgraf on the Long Island Railroad in New York. This is a real human being. Now, Mrs. Palgraf, may she rest in peace, was a real human being, but she don't mean much to you. So I always make sure that I introduce my client, because most of my clients, unfortunately, I never met in life. I meet them all through their family, their friends. And John was a superb guy. He would write, he was a night shift worker, so he would send his wife all these cute little biblical quotes and then fine-tune them to his own words, like having a good thing. I don't think that's in the Bible, but he was a wonderful father to 2 children. We got just a little bit of time. I'll tell the guys in this room will love it. I don't know how TikTok works, but that young man in the picture, he posted something. His dad's favorite team was the Detroit Lions, go figure. And he posted this thing, and so I guess they answer like days later, and it was the Detroit Lions' best running back, and they played it in front of the jury, and so he's sitting here trying to express to this football player who he and his dad loved that his dad had been killed. And the guy is going like this, and he says, I don't want money, I don't want tickets, I just want something to remember my dad and his love for you all. And he picks up his helmet, the football player, and he's got John's initials. And the next scene is a real Detroit Lions snap, and everybody on the line smashing into each other has John's initials on their Detroit Lions helmet. And they did that for that young man. This is important, not just because John was extremely religious. This is important because he would get off night shift and go to nursing homes to visit with people and read the Bible and witness to them. After a whole night of work, that was the kind of person John was. He went to Haiti after the earthquake and built schools and churches for the children there. And I'm going to show you that top right picture is one of my favorite pictures of John with all those little kids making faces at the camera. He liked doing that so much, he took his family every trip thereafter until the U.S. State Department said, Mr. Gillenwater, it's not safe anymore. You can't go.
I love you, baby. I hope you have a great night. I appreciate you. I sure am glad you're mine. Bye.
That's how John would say goodnight to his wife and to his kids, because he was a night shift worker. And you just saw the last thing I played to the jury in my closing statement. And I sat down before, and it was over. And it was up to them to do the right thing by John. I told the jury that, we ask a jury to put a price on the priceless, and yet, under West Virginia law, I can't even tell you what a reasonable verdict would be. I can't even mention it. I did not, and you find another lawyer in this state who would do this, I did not put his lost wages into evidence. That's how special a man and how special this family was. And I got the second largest wrongful death verdict in the history of the state. Plus a whole bunch of settlements that, thanks to the dummies in the legislature, we now have joint liability. And so I got to collect all that, plus my verdict. So it worked out great. Those are the ways, though, that when you talk about the burden of proof, reasonable doubt, cause and fact, not reasonable doubt, cause and fact, proximate cause, that's the way you put the meat on those bones so that the people in the jury box are rowing with you. They want you to win this case. Most people in this state, a lot of my friends, would put the widow on the stand and have her talk about how horrible it was to lose John, how awful it was. I did none of that. I asked her, how did you ever find joy after living through something like this? How did you recover from this? And one of the ways she did it was she would write him letters on his birthday and at Christmas and on their anniversary. I had her read 2 letters to the jury at the end of her direct. She was our last witness. I couldn't even rest our case. I had to turn to young Mr. Amos. And by the way, when I call him young Mr. Amos, that's not derogatory, because he's going to inherit my law firm. That's how I refer to him when I'm in settings like this. But anyway, he had to rest our case. I couldn't get my throat open to tell the judge, the plaintiff's rest. How hard is that? That's how emotional and how wonderful she was. And I didn't want to dampen the impact of this loss and the fact that I could prove that my client lived consciously for 1 hour and 16 minutes. And the reason is because on the run sheet in the ambulance, and if you read a run sheet once, you're not doing your job. You got to read that run sheet 20, 30, 40 times before you even meet with or depose the ambulance driver or the guy who was in the back trying to take care of the patient. And I asked the judge, I said, can he stand up? I don't want him to come down and show him how they administer the medicine. And the judge said, sure. So he stands up and I said, how do you get medicine in someone who's burned on 90% of their body and blind and can't breathe? And he goes, oh, you drill holes right here in both legs through the bone and administer the painkiller in there. So he's conscious while they're drilling holes in his bones, and they recorded the time they shot him with the medicine that would allow him to no longer suffer. Now, how worried do you think a normal jury is going to be about proximate cause at this point in the process? I've given you what it takes. You have the tools. Now it's up to you to do something that I've been struggling for 2.5 years to do for the Gillenwater family. I give that burden to you. And believe me, I'm nervous doing it. But that's your burden now. I've done my best for them. I guarantee you they didn't go back there and talk all afternoon about proximate cause or the reasonable corporation. Those are the kind of tools that you use. Can you set my next one up for me, please? Hello? Oh, there he is. Thank you. Very kind. Thanks. If I touched that machine, the room would blow up. Okay, this is a case, actually, I thought that Ed Amos, my partner and the person who will inherit my law firm, I thought that he was going to try this one alone. But I found out that Heather had 2 little boys. And the little boys weren't hers. And I said, well, Ed, how'd that happen? And he said, well, the mother was a drug addict and overdosed, and she got a boyfriend, and these 2 little boys were her boyfriends. And I said, but they still call her mom. And he goes, oh yeah, she goes to parent-teacher meetings. She goes to the doctor with them. I said, but she broke up with the boyfriend, right? And she said, yeah, but they still stay at her house 2 or 3 nights a week, and they still call her mom. And I said, you know, Ed, maybe I'll come down and try this case with you. And so we want to now close the case, and we want to help the jury with the judge's instructions. Because remember, the judge got you to the finish line, right? So the only thing they're worried about now is that the instructions don't create reversible error. That's their biggest fear at this point in the trial, because they've gotten all the evidence in. The defense's evidence is in. But if they give a lousy instruction, the case gets sent back and they got to do it all over again. And who wants Scott Siegel in their courtroom all over again? So they're very careful with these. But the jury doesn't understand any of this, right? So here it is, right? You've all read this 1,000 times. This is the standard. It's in the judge's book or the model jury instructions, which I got reversed as not being the law of the state. But there's still a lot of good instructions in there. And this is the one on the burden of proof. Okay, this makes no sense. None. This was actually 2 slides. I condensed it today into one. And what it is the first slide, it says not malpractice, and they're even. The second slide, it says malpractice, and there's a feather on it, and the little fulcrum or whatever is tipped ever so slightly with the feather. And so you use things like this to say to the jury, that's all that means, is that you just have to have that much more evidence. And actually, in a maritime case in federal court, you get an instruction that says a feather of evidence. Now, here's the credibility of the witnesses. I don't think you got to weigh this and you take into account their emotional, you see how good their memory or lack of memory, blah, 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 blah. Young Mr. Amos likes cartoons. Before I showed this to the jury, I told them, I don't want you to think that Heather's case is in any way something comical, but by the same token, young Mr. Amos worked all night on this, and I actually thought it was pretty good. Because when we talk about the credibility of the witnesses, all these witnesses agreed, except for the defendant doctor who was on an island by himself. And I thought that illustrated it pretty well. And I went through what those various witnesses had said during the course of the trial. This was the failure to diagnose a leak out of the intestines, and they kept washing her gut out and giving her drugs, and that ain't a good way to deal with a leak, because if you don't stop a leak, the patient's going to get sicker and sicker and die. And it's called source control. And so the prima facie case, you have to show these things, okay? Now, that's the prima facie case. What do you think she's doing in that helicopter near death, all tubed up? You worried about the prima facie case anymore? Those are the medical articles that we had gone over with my expert to explain to the jury that source control has been the gold standard, the standard of care for over 100 years. This wasn't some little mess up. If you don't stop the leak and poop keeps going into the gut, your patient's going to get sick, septic, and die. Fortunately, they flew her up here to Morgantown before she died. These are just some of the things you help with the prima facie case by showing the jury that they didn't fix the leak. And you can use these medical exhibits through your expert to explain it to the jury, so by the time you're in closing statement, all you have to do is say, they didn't fix the leak. It's there in black and white that she had air in her gut and she had this in her gut. They didn't fix the leak. And am I sure they didn't fix the leak? Here we are at WVU, a liter of enteric fluid is removed. So what did I do? I got a liter bottle and filled it with Hershey's chocolate milk. And I grabbed it off the table in rebuttal, and I held that bottle up and I said, that's how much poop was in her gut? And they're telling you they fixed the leak? And there they are looking at a liter bottle of what they thought was, and it wasn't, but just more records that demonstrate. And then finally, I didn't do it because it got sealed. It's a long story, but that jury verdict form will never see the light of day. It got sealed after the defendant agreed to pay the policy limits and the doctor paid the court cost out of his own pocket. And so even though they'd reached a verdict, the judge was very worried about that document ever seeing the light of day. And so nobody's ever seen the document, including the judge. It was Judge Swope, by the way, and he did a masterful job trying this case. But then I get back to, don't lose sight in your cases of the fact that this isn't Mrs. Palsgraf. This is a real human being who still takes care of 2 children as though they are hers. This is a woman who rode horses, who did all these activities with these kids, raising them. And when you don't do your job, that's what you do to a human being. So I promised that I would leave a little bit of time for questions and answers. I will, at the end of this, tell you why a 70-year-old man threw 3/4 of the way across the United States from Jackson Hole, Wyoming, to be with you. I will do that at the end because I want to give you time. That was a lot of stuff to cover, but I wanted you to see how we take what you learn and I learned here and extrapolate it into evidence that a jury can understand why Cardozo said that Mrs. Palsgraf had to be compensated for what happened to her. And you can't read them Palsgraf versus Long Island Railroad and expect them to understand what the heck it is you're asking them to do. You have to use tools like this. I'll tell you one last story, just you'll hear this in trial ad in a year or two, but I'll tell you one last story about this trial that's one of my favorites. Ed Amos and I, rarely depose the defendant doctor. You know, oh, you don't. Why would I want the defendant to know where I'm going on cross-examination and give him a trial run in a deposition? So they had an expert witness who I never deposed. And some people still preach, you never ask a question in cross-examination you don't know the answer to. You've all heard that probably already, right? So they put this guy on the stand, and he's really good, and he's really nice. And so I get up and I said, Doctor, I said, you went to Northwestern Medical School. Yeah. I said, that's a pretty good medical school, really good medical school. And he looked at the jury, and he looked at me, and he looked at the jury, and he looked at me, and I said, Doc, it's okay to brag on yourself. That's a great medical school. He said, yeah. I said, now, in critical care and all this stuff you did at all these hospitals, how many bad bellies, or the medical word, don't worry about it, the jury was bored with it, they like bad belly better. How many of those did you treat? Oh, I would treat 8 or 10 a week. I said, well, as a critical care surgeon, how many would that add up to now that you've retired? Just give us a ballpark. Oh, I would say probably 40, 42,000. I said, you treated 42,000 bad bellies in your career? Yes. How many did you ever fail to achieve source control in? And he turned white. And the jury wasn't 4 feet from him. I said, please answer, how many? And he said, never. I said, that's good, thanks, that's all the questions I have. So sometimes you do ask a question you don't know the answer to. Anyway, I've taught 3rd grade at Elkview Elementary. You're not going to ask me any questions that are going to embarrass me. They raised their hand, they said, ooh, how many cars do you drive? I said, that's the wrong question. You're supposed to ask me, what kind of jet do I fly? So please feel free to ask me any questions that come to mind. Don't be bashful, please.
Have you seen a decline in the amount of cases that actually make it in front of juries? As far as like being able to present a case like this?
Yeah, so let me answer that question fully for you. First of all, when the client comes to us, I tell them, I'm going to prepare their case for trial. If they decide to settle, that's their business. Unless something materially happens in the case that affects the valuation, I tell them that that's going to be their responsibility at the end of the day. If it's a case that involves a catastrophically injured child, I will make the parents hire a trustee so that that person makes the decision, not the parents, because the guilt of that decision is overwhelming if you have a catastrophically injured child. So that's part one. Part two to your question is, yes, trials have dramatically dropped off, mainly because A, state court judges don't have time. All they see is abuse and neglect and drug cases. And they see me come in with a big defense group on the other side, and it's like, oh God. You know, I actually had 2 judges stop me on the streets of Charleston after I tried the Gillenwater case and asked me, how did the judge find time to try that case for you? We got our case in 4 days in Gillenwater. And the defense, I think, took another 3, boring the jury to death. But I actually had 2 judges stop me and ask me, how could a state court judge do that? And they were state court judges. That, and the second thing is the heavy reliance upon mediation. I only go to mediation with one mediator, the process upsets me. I'm not good at it because I get all upset when they come back with what the defense thinks and start doing closing arguments, and the clients get all upset and confused. But I think that for the most part, mediation, and it's always court ordered now, and in federal court, a lot of times they use the magistrate. And the magistrates are really good at it, but the problem is, do you really want the magistrate going back and telling the United States District Court judge it was Siegel's fault this case didn't settle? So I think mediation has become a reason that we're seeing a lot of clients get to the point where they say, I can't gamble that much money. I want you to take that. Ed Amos is very good at that process, and he does a really good job with our clients, preparing them for the process. And so I believe those 2 factors. In a small county, I think you can still get judges who will try civil cases for you. A case the magnitude of Gillenwater, you're always going to be able, I think, even today, find a judge who's willing to try your case. And in that case, we didn't have any choice because we'd settled with 2 out of the 3 potential defendants, and so it was going to go to verdict. Everybody knew it was going to go to verdict, and nobody but was going to blame it on me, although it was my fault. That's an honest answer to your question. I hope I answered it. Yes, sir.
When it comes to trying to get clients to settle, especially in these cases against corporations, how often do you use that emotional appeal that you do in trial? And if so, what would be, what am I saying? What portion of your overall argument would that be?
With the client?
When trying to get a corporation to settle or settle out of court.
I'm no good at that. I rarely can help a corp. The only time I can help a corporation settle is.
I meant against the corporation.
Yeah, I mean, if I know their lawyer really well, or if they send someone from the corporation who the mediator can get in the room with me, so I can talk directly with them, with the mediator, because they have the money, the lawyers don't. So if I can get, like I did a helicopter crash up in northern Pennsylvania that killed 2 linemen, and fortunately the vice president, senior vice president of the insurance company for the helicopter company came to the mediation, and he and I did, you all are probably too young, but the crash of N-79 SP that killed 2 West Virginia state troopers about 20 years ago, he and I were on that case together, and so he trusted me. He knew I would try the case if push came to shove, and we were able to get it resolved. The emotional part of it with those people don't work. I mean, they're bean counters. Now with my client, I never encourage my clients one way or the other. I only tell them, you know, it's like I told Mrs. Gillenwater the first time I met her, I'll never bring your husband back. I can't do that. They didn't teach me that in law school. I wish I could, but they don't teach that class in law school. And I said, someday there's going to be a pile of money on the table, and you're going to have to make a decision, and you're going to have to live with it, not only for you and your kids. I said, now I'll explain everything to you. I'll help you. I'll make sure you understand all the risk and all the good stuff, but ultimately it's up to you what to do. And I would never push a client one way or the other, unless there was something really problematic in their case. And then I would say to them, look, this is a lot of money for you and your family to risk, and you've got this major problem in your case that I can't make go away. So that's how I deal with it from both perspectives. I hope I answered your question. Thank you, sir. Let's do this one, and then we'll get...
Two-part question. How did you get into personal injury and medical malpractice, and then how did you become so good at it?
So I'll answer the question, but I want to tell you a quick little story. We're going on, what time did we finish, 3:30? Okay. I'll tell you a quick little story that's cute. So back in the old days in New York City, they used to have these little kids who were runners, and they would do it for pennies. And there was a guy, and the kid had to make a delivery to Carnegie Hall, which is the premier concert center in New York City. And he saw a guy with a violin, and he goes, I bet that guy knows where Carnegie Hall is. So he runs up to this old man who's walking with this violin, and he goes, sir, I need your help, I need your help. And the violinist looks over, and he goes, how can I help you, young man? And he goes, how do I get to Carnegie Hall? And he goes, practice, practice. That's one answer to your question. Another true story, I walked into this building. I was accepted 4 days before law school started. And they handed me this little slip of paper. We didn't have computers back then. We had horses with saddle, no. But they handed me this little piece of paper. It said Con 1. Okay, Constitutional Law 1. I got that. And then it said Contracts 1. I'm like, I got that. All right, we're good. Legal Writing 1. Okay, I understand that. And it said Torts. I said, hell, they could teach baking in law school? That's a true story. That I swear, hand to God. So what happened was, in my first year, you had to do the Baker Cup. And we had a problem that actually ultimately made it to the US Supreme Court years later about whether or not you could patent an enzyme, a life form, that had been tricked to eat oil spills. And I studied a lot of science in undergraduate school. And so I made it to the final round. And I thought, wow, I got a gift of the gab. I might be able to pull this law school thing off anyway. And so then the next year, my second year, we started the Lugar trial program, which if you made the team, you were in it for 2 whole years. So by the time I left law school, I'd probably tried, between the law school competition, the regionals, and the semi-regionals, I probably had tried 30 lawsuits to real judges by the time I walked out of this building. And then for 10 years, I starved to death because I wouldn't work for anyone else. And so I did dog bite cases, whiplash cases. Back then, you had to do criminal cases. Crazy kid walked out of this law school, went to a judge on a Vietnam veteran and said, Judge, I have a psych degree from the University of Vermont and a law degree. I can represent Jimmy Doodle in his 2nd, 3rd, and 4th felony for which he would go to prison for life. But I can do it, Judge. And Judge Booney Somerville, may he rest in peace, said, Scott, if you think you can do it, my partner at the time had post-traumatic stress disorder. He had been in the Phoenix Project in Vietnam. And he said, Scott, I just can't do this case. So I did it, and I learned an awful lot from very, very good people about post-traumatic stress disorder. And as I tell the students at the University of Vermont when I lecture on psychology and the law, Jimmy Doodle died in a tree fall accident in Upper Peninsula, Washington, but he didn't die in a cage. And so that's how I learned. And I always kept my interest in science and medicine. And I tell the beauty of of what you're learning, the tools that these wonderful professors are giving you. The beauty of it is if you do what I do, you got to learn something new every day. I mean, today, I'm studying metallurgy. Tomorrow, I'm studying source control in the surgical manuals. The day after that, I'm studying why they didn't ventilate a child in the first 4 minutes of its life and give it permanent brain damage in a damn hospital in Idaho. I have to learn something new every single day, and you will. And if you will get really good at this stuff, the most enjoyment you're going to get, because you don't see any joy at my office. There is no joy. Every person I meet, it's a horrible tragedy. That's why I live in the mountains and go skiing all winter, even though I'm 70 years old, and drop off cliffs, is because I have to remember that there's joy in this world. There's beauty in this world. I sleep with 2 100-pound Bernedoodles and my wife. I have to be reminded that there is joy. And you will too if you dive into this. But in doing that, you do get to learn, and the scientists I've gotten to work with over my career have just been absolutely unbelievable. Then, in the last 15 or 20 years of my career, I was inducted into the inner circle of advocates, and so I have a law firm of 100 of the greatest trial lawyers in America that I can rely upon. Most of the ideas you saw in that slideshow, I stole from one or more of them. And I brought a reading list for both of your professors. I assume they can send it to you, that has a lot of stuff that my fellow Inner Circle members have written. And by the way, I don't have any interest in the Trial Guides Publishing Company. And if you notice, a lot of these books are published by them. I don't have any financial interest in it. It just happens that's who most of the Inner Circle people write their books through. The other thing I think is that some of the old masters, and a lot of them are on here for you, but interestingly, like 4 of the books that I recommend are Thinking Fast and Thinking Slow, written by a Nobel laureate, The Body Keeps Score, one of the most fascinating books that you'll ever read about how we carry with us our life experiences. Sapiens is another great one. So there's a lot of stuff that you can read and learn from that'll help you. And that's how I got as good as people think I am. I think the other thing, because I want your question's a serious one, and although I try and make light moments of things, the other thing that most law students, nobody tells them is, you have to open up a very dark part of yourself with the jury for them to believe. So for instance, and this is going to sound funny, but it wasn't, when I was in this case, the Gillenwater case, the explosion, they were trying to blame every other chemical company involved. And so I told a story about when I got in a lot of trouble for taking a couple bucks out of my mother's purse to buy a hamster. And I shared, and you could feel my anxiety sharing that, and how it wasn't a very good day for me or my brother, and I had to shine shoes for a whole summer. And back in the 60s, men wore white shoes to work in the summer, so it wasn't such an easy debt to repay. But you have to open up parts of yourself that are not comfortable in order to connect with people, because you have to remember, and I don't know the exact statistic right now, when I stand up in front of a jury and I say, "Good morning, ladies and gentlemen of the jury," 85 to 92% of those people believe I will lie to them for money. Before they ever hear or see what you saw, they believe I will lie to them to get money. So that's the other part that's really hard to learn and takes a lot of practice. I have time for one more, and then I want to tell you the end of my story. Yes, ma'am?
Yeah, mine was similar to his. I was just going to ask if you liked Torts class when you went here.
Well, I remember Mrs. Paulsgraf, so obviously, yeah, I ate it up for sure. I definitely, once I figured out that I had the gift of gab and that I could actually pull this off and make it through 3 years here, that was kind of my destiny. And it was going to be that. So, the end of my story, and then I will let you all go on with your lives. Why does a 70-year-old man fly 3/4 of the way across the United States of America to spend an hour with you? Well, there's this old judge up in the northern panhandle. And whenever he gets a jury in the box and the jury's sworn, he looks down at him and he says, you know, you don't have to be a rocket scientist to get on a jury duty. You all saw how to do it, and you chose not to. And I want to remind you, people died so you can sit in those seats. So whenever the defense is going through their opening statement or their closing argument or their depositions, I'm the first one in the courtroom every morning. I always ask the bailiff what time he's going to unlock it. And I don't sit there reading my notes or worried about what I'm going to do on cross or closing or opening. I think about 14, 15, and 16-year-old boys being shot by redcoats with bullets that would take them hours, if not days, to die. So that I have the privilege of standing up saying, good morning, ladies and gentlemen of the jury. Thank you all.
Thank you all for being such good audience members. Thank you, Scott, so much for sharing with us. We really appreciate it. Okay, I think that's it. If you're a member of the West Virginia Trial Lawyers Student Association, we're going to meet with Scott at 4 in Bowers Room. And I think some of our Luger members are going to also attend. So, okay, thank you all so much.
In my class, you're not off the hook. Same classroom.